Welcome back to Just Settled. We are here today with a returning guest, Joseph Gates. Joseph, it is so good to have you back with us. Thanks for joining.
Yeah, thanks for having me back on. I certainly appreciate it.
Yeah, and just to remind the audience, Joseph is the founder and trial lawyer at Gates Law Firm in Little Rock, Arkansas. So personal injury, car wrecks, product liability, you cover all of those for the people of Little Rock, and I'm assuming greater, area of Arkansas as well.
Yeah, Arkansas is a small state, so I travel all 75 counties, and I found myself working out of state as well. So
Okay. And we were going to talk a little bit today. I know you had a few different angles you wanted to cover in this episode. It was definitely a product liability sort of case that seemed to split off into a bunch of different directions here. So I'm curious to kind of get your insight on it and kind of, how you handled this. Can you kind of overview what we were just talking about before we got on the episode and kind of, just what this product was, what happened, and kind of how you first learned about the issue and then kind of came into the case?
sure. So I previously represented a man who was working at a construction site, and I asked you earlier, have you ever heard of a multi-piece or a split rim? And you looked at me like I was a crazy person. I was like, well, yeah, I'd never heard of that either until I worked this case. But when back in the old days, when tire, as we know on our cars and trucks and whatnot, the rim itself is just one big solid piece of metal and stuff. But back in the old days where as tires got bigger, to manage it, they would split it up. And so it was called a split rim or a multi-piece rim. And it could have, there's some models that had two, sometimes three, sometimes four pieces. This particular rim was a three-piece, multi-piece rim. And so the danger point comes with that as you air it up, the pressure from, so it had the base rim that was connected to the machine, then it had a lock ring piece, and then it would have like a ring around it that would kind of hold everything together. But the ring around it was very thin, and so the danger is as air pressure starts putting on getting in the tire and molding against the rim, that little piece, it could separate. And when it separates, man, it's like a cannon, and it shoot out, and the other piece that was connecting away from the base rim shot out like a cannon, and it hit my guy and severed his leg clean like it was a freaking lightsaber. It's amazing and it happened so fast. Well, it pushed him back several feet, and so he had a head injury as well. But when the piece cut his leg off, it cauterized it as well. So there wasn't a bleed out situation. It was very remarkable that he's still alive today. He's in bad shape, but he's still around.
Severe. So this person came to you obviously after the injuries and was wanting to find liability or to sue whoever they could go after to kind of recover costs and pain and
Sure.
suffering.
What made this case unique was how old the product was. So this would have happened in the mid 2010s.
Okay.
This machine was manufactured back in the 70s. And so in certain states, like Texas, for example, like there's what we call a statute of repose, which is like a statute of limitations on products. Like if something's out in the marketplace for 20 years or something, then it's like, it is what it is. But in Arkansas, we didn't have something like that. So we still had an ability to make a claim against the manufacturers of this product.
When you say that this was, the machinery itself or the product itself was from the 70s, was that a concern or an uncertainty in terms of how that case was going to play out? What were sort of some of the concerns? Was one of those, I don't know, the fact that this was that old of a thing, or I mean, how did that come into play?
So the main concern is like no one from those companies were around. It was like 40 years ago. So how do you get testimony? Thankfully, there were documents, and so this design had been around going way back to the 50s. And so I've got a photo in my office of I went to I saw original documents I understand what carbon copy literally means. And so back in the old days, they would have three pieces of paper. There would be the paper, and then there would be a piece of onion paper under it that could like bleed onto it. And it was a carbon copy.
Yeah.
So when you send an email and you CC someone, that's what carbon copy means. And so that's just, I never knew that until I was there looking at documents from the 40s.
Yeah, it's like a triplicate or something, I think it's called.
Right. So, this design was one of the first multi-district litigation cases that existed back in the 80s. And so they were under court order to keep documents preserved in perpetuity. So once we figured that out, even though the people who designed all this weren't around anymore, their testimony was preserved. And so, but it was combing through 30,000 plus pages of documents, more than that of boxes. Like we used about probably condensed 30,000 into like 1,000 that were workable, but we probably reviewed hundreds of thousands of pages. So, but thankfully it was all preserved.
What did the timeline of this case look like from start to finish? When you first were brought on to the end, how long did that run? What was that like?
Well, this one took a little bit longer than I would certainly have liked. I mean, it was several years. Part of that problem was the people who used to litigate this case, this design essentially has worked itself out of circulation. So there wasn't anything like new that we could there's an expert here that could work on this. Like we found the one expert that still worked on this, and he was getting on up there. So it took a while to figure out what the problem was. And then when we discovered that there was an MDL that existed, then things accelerated. So because we had the documents preserved, the defense was not being the most forthcoming on this, even though this was a known issue. So it took a few years to get it postured for resolution.
And when did you kind of know that there might be a settlement here as opposed to going to court? Was there sort of like a tipping point or some moment where you said, okay, this actually could become, go to settlement?
Well, it wasn't at the first mediation. The first mediation failed. The parties were too far apart. I don't think they realized that we had the goods. And so, we did the first mediation after the first round of depositions, which would have been the plaintiff and maybe the treating physician. But so that one didn't work. No one was ready to come to the table. So after that mediation failed, we had another round where we did 30B6 depositions, which went well because we had the documents. When you have the documents, you can control the witness, and they have to make concessions or they look dumb. So it's get the documents is no one else takes anything from this. Find the documents. Then we had another round of mediation, and it didn't settle at the second mediation. But the parties were close enough that the mediator who did both mediations did a great job of leaning on both parties, even after we're not in the room for the mediation. So over the next few weeks, this was actually at the start of COVID when it actually got done. So we had the trial date that was pending that was really putting a lot of pressure on the parties. And so I think even with COVID, I think we could have maybe tried the case. But I would say, 2 failed mediations, but after the end of the second one, the parties were, close enough, a few 100,000 apart, or maybe even 1 million apart or something like that. But it was close enough that made us feel like, okay, we might could get there. And then with the pending trial date, we figured they would come up.
And I know that insurance companies, no matter what, they always lowball right when they start. What did the negotiation process look like here? I'm assuming, again, that they attempted to minimize compensation. How did you advocate for your client, who obviously sustained a horrific injury?
Right. This one was unique in that there were multiple parties, and they really blamed our guy. That was how they started. And then once we showed them that this was a known design problem, and they had an alternative designs even way back when, but because of production costs of retrofitting the companies, they didn't want to spend a little bit extra money to retrofit it, that they could do a safer design. So I made classic profit over people, right? And so once we got the goods on those documents and we showed them that through 30B6 depositions, I think they realized, okay, these guys kind of know what they're talking about. And so that put a little bit of fear in them to get it postured. They kind of got away from blaming our guys. Like, well, I mean, you walked them into this problem.
Yeah. And when everything sort of resolved and the settlement happened and everything, I know this is a confidential settlement. You can't speak to the actual amount, but how did it positively impact your client? I mean, again, I'm assuming they needed specific special medical equipment and things like that to
Yes.
live okay. And
So for his situation, we certainly engaged a financial group because don't ask me for financial advice. So we engaged a group that specialized in that and helped him devise the plan where he got some good money up front so he could buy him a nice home that fit his needs, and then figured out a way. Okay, how can I live off the interest? And so to this day, I think he's more or less living off the interest of the settlement, and that's meeting his monthly needs. Plus, if things go bad and he needs to draw more for any kind of medical needs, he's got a very good nest egg.
yeah, obviously I was very lucky to come across you. Did you want to, I think you mentioned before we spoke too on this episode, you wanted to touch on a couple of points like insurance points or just kind of more generalized things that you kind of thought were helpful for people to hear?
Well, one thing that helped, two of the defendants were self-insured, so that's a different type of negotiation because you're actually taking money from them instead of an insurance company. But one thing that the third defendant had insurance, and so one thing that helped us against that particular defendant was the threat of an excess verdict. So what we were showing them is like, hey, even if you're 30% at fault, like if a jury finds you that little at fault, the damages are going to be so big that the verdict times the percentage is still going to be bigger than your policy. Right. And so that can posture an insurance company into a bad faith position for a negligent failure to settle. When that happens, that really gets insurance companies motivated to do the right thing in cases, because in that particular situation, like say there's a verdict that exceeds the policy, if there was an opportunity to resolve it beforehand, the insured or the person who's now hit with that judgment, they can have a direct claim against the insurance company for, hey, why didn't you take care of me? You knew that this was going to be a problem, and now I'm out above my policy because you didn't want to take care of it. And so what practically happens is that the insurance company then pays above and beyond the policy.
Yeah, it's interesting how all these mechanics kind of come into play and these little angles that you have to kind of watch out for and be aware of. Well, again, Joseph, thank you so much for sharing this case with us today. We'd love to have you back on Just Settled again. Sure. Again, for anybody watching, Joseph Gates, founder and trial lawyer at Gates Law Firm, Little Rock, Arkansas. Joseph, where can our audience find you or people find you if they need you?
Well, so the website, gateslawplc.com. We've got a Facebook and LinkedIn, Gates Law PLLC. So yeah, and my email, gates@gateslawplc.com. Happy to share. One thing that I value is collaboration, and if you have any kind of issue, I'm happy to visit and share everything I have, because I truly believe that this is a calling. It's not just a business, and we're all here to advocate for our clients. And if anything I can do to help anyone, I'd be happy to.
Awesome. Well, thank you so much, Joseph. Again, we hope to have you back soon.
All right. Thank you. Appreciate it.